The First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. All right, we have two related cases on our docket this morning. We'll take them in the order that they're noticed, the 94 case and then the 96 case. And we can do them one after the other, and we can take a little time to break between the cases. There's no need to switch sides or anything, but we can just keep going. So if counsel for the first case is case number 22-2094, Verizon Communication Affiliates versus State of Florida Department of Revenue. If counsel for Verizon is ready.
Does it matter?
That is true. Well, I'm Thomas and she's Kelsey, or you could just say, hey you, how about that?
Thank you.
Thank you.
May it please the court, Michael Bowen for the appellant, Verizon Communications, Inc. and Affiliates. I'd like to reserve 3 minutes for rebuttal.
Noted.
The order of the lower court granting summary judgment to the department must be reversed for the following 3 reasons. First, the legislature has made clear that Florida's tax laws conform to the Federal Internal Revenue Code, unless the legislature has stated its intent to the contrary. The legislature has not disassociated Florida law from the federal mitigation rules in the Internal Revenue Code. Therefore, consistent with this legislative intent, the federal mitigation rules are part of Florida law. Second, in Seaboard Coastline, this court explained that the legislature's intent was to harmonize Florida's corporate income tax regime with the federal blueprint. In that case, this court determined, without controversy, that a concept of federal law substantially similar to the mitigation rules was incorporated as part of Florida law. Finally, the fact that Florida's statute of limitations may be a statute of non-claim is irrelevant to this appeal. The statutory language of the federal statute of limitations has also been determined to be a statute of non-claim. Yet the IRS and federal courts routinely treat the federal mitigation rules as an exception to the federal statute of limitations.
Counsel, let me start there while you're there. There are a couple of statutory things that for me seem to be very important on this issue. And the first on the non-claim, I think that's 215.26.
Yes, Your Honor.
Is that right? And subsection 4 says this section is the exclusive procedure and remedy for refund claims between funds and accounts in the state treasury. First, it says this section is the exclusive. So is there anything about mitigation in this section, and how do we deal with the fact that this section, that this law says it's the exclusive place that we should look?
First of all, subsection 4 refers to the exclusive remedy, meaning if you're going to pursue a refund, you have to do it pursuant to 215.26. It doesn't talk anything about exceptions to statute of limitations. It says that's the sole remedy. Secondarily, the United States Code, section 6511, has a federal statute of limitations, which is substantively identical to Florida. It's not exact, but identical in its language. And that statute has been recognized to have an exception to it as the mitigation rules. I hope I've answered your question.
Okay, but you are seeking a remedy.
We're seeking a refund.
Talk to me about the remedy that you're seeking and how that doesn't relate to this section.
Well, we are seeking a refund, and we have pursued a refund claim consistent with Florida law. The department has not said that our claim is deficient, meaning we have followed all the rules to pursue the refund claim. The amount of the refund claim hasn't been challenged. The timeliness of the claim having been raised has not been challenged. And ultimately, the federal requirements under mitigation have not been challenged in this case. There's been no dispute as to any of those facts. The only issue for this court is whether Florida law adopts the federal exceptions to the federal statute of limitations under Florida law.
Can I maybe rephrase that a little bit? More conceptually, it sounds like you're kind of relying on federal concepts as controlling Florida law, but it seems to me that this court can't pick a concept out of thin air and inject it into rules and statutes where the legislature and the department haven't done that. And that's more, more conceptual way to look at this argument. Can you address why we should read that in there when the legislature and the department have not done that?
Yes, Judge Kelsey, and I will disagree somewhat in the sense that Section 220.02 of the Florida statutes states, quote, "It is the intent of the legislature that the income tax imposed by this code utilize to the greatest extent possible concepts of law which have been developed in connection with the income tax laws of the United States." This was put in place the exact same year that Florida adopted and enacted the corporate income tax provisions that we are dealing with here today. So the legislature of Florida articulated its intent to borrow from federal law, which makes sense if you think about it. The United States corporate income tax has been around forever. There's no need for Florida to reinvent the wheel. So the only thing that Florida really need do is come up with whatever exceptions it wants to deviate from the Internal Revenue Code. That same Florida statute, 220.02, articulates all the reasons why it makes sense to borrow from the federal provisions, most notably efficiencies to both taxpayers and the department of not having to recreate the wheel every time they want to try and solve a tax problem.
That was the other part that was important to me here. The rest of you read the rest of subsection 3 that you just read talks about the intent of the income tax imposed by this code utilize the greatest extent concepts of law in order to. There's a purpose statement there, and it seems like, just as you said, that the purposes there are efficiencies. To minimize expenses of DOR, to minimize costs and difficulties for taxpayer compliance. And so this utilization seems to be for the purpose of efficiency, and I understand your argument as to mitigation to be something that's more in the nature of a fairness and equity concern and not particularly efficient, because it seems like you'd have to keep records for an additional long periods of time, and we're arguing about things that are 23 years old and things like that. Why does this section as drafted even apply when we're not really talking about an inefficiency, but maybe a more fair outcome?
I think that there's been I was going to get to this a little bit later in the argument, but I think it's important to address it now. The department's concerned that there's some sort of inefficiency here. There's a records issue. The mitigation rules, again, apply in very, very, very narrow circumstances. Even in federal law, it rarely applies. Only under certain very discrete, specific circumstances that the department has not questioned have been met here. So the statute of limitations can only be reopened under very limited circumstances. It is true that the tax years that we're talking about here, again, which the department has not disputed, go back a ways. But again, Verizon is not a small taxpayer. The audits of taxpayers like Verizon do take time, and the actual audit years are before this quarter, 2011 through 13. So even they are old. The reality of what happened here is that Verizon was not made aware of its ability to qualify for mitigation until certain events took place, events that federal law anticipates would happen and did happen here. So, the one other issue, Your Honor, that you mentioned is record keeping. The department's concern about record keeping has nothing to do with them. In the event that this court were to determine that Verizon qualifies for the mitigation, it's Verizon's burden to have the records. Verizon just can't say, we qualify, therefore entitled to the refund. They still have to be able to substantiate that they're entitled to it and with their own documentation. It's their obligation to retain the records, not the department's. So in the event that there's some sort of inefficiency, it works to the detriment of the taxpayer in this case, because it is the one that had to have the records substantiate the refund. Now, Judge Osterhaus, in this case, that doesn't matter. And what I say by that is the department's conceded all that. They haven't disputed the documentation exists. They haven't disputed the amount of the refund. They haven't disputed the tax year to which the refund relates. They haven't disputed that the mitigation rules have been satisfied here. So all of this smoke and mirrors about record keeping and slippery slope of the long period are really just a function of the fact that Verizon is a very big taxpayer. The audit took a very long time to be audited. And Verizon has a situation where they've already had the documentation. Now, in many mitigation cases, you might not have to go back that far. Documentation would be easy to have. But again, this is the taxpayer's burden.
Well, and I think my question goes to more of a 35,000-foot level question of, you're asking us to read into the non-claim statute an intent provision of Florida law, and the intent provision is bent on efficiency, and your argument really isn't about efficiency, it's about fairness and equity. That's what mitigation goes to. It doesn't go to efficiency because it's not particularly efficient to have an overlay of mitigation rules on a very clear rule. Why do we read in something that's bent on efficiency as changing something from efficient to an inefficient rule?
Well, I think that the federal statute of limitations, again, is also a statute of non-claim. And certainly efficiency is important to federal law as well, but it's a well-recognized exception to the federal statute of limitations that they have the federal mitigation rules apply, is a very, in this case, it appears inefficient, again, because of the age of the years that we're talking about at the end of the day. But that doesn't always have to be the case. But one more point, Your Honor, I want to get out, is that the mitigation rules work both ways. It's not just, it happens to be in this case that Verizon can benefit from the use of the mitigation rules. The department under the federal mitigation rules can also benefit. For example, in the event that the department were to have allowed Verizon to take a deduction in an old closed tax year, erroneously allowed Verizon to take that deduction, and in the current year it allows them to take it again on the same return, legally take it again, the department could use the mitigation rules and open up that closed tax year for Verizon and assess Verizon for taking the deduction the wrong year.
Yeah, and I get all that, and I get why that might be the best rule, but what I don't get is a statute of non-claim is very efficient, right? It's clear, and either you are or you aren't, you're in, you're out. To overlay mitigation rules introduces a lot of, okay, what's happening here, and should this come in, and it's not efficient. It might be a better rule, fairer rule, policy-wise, but for a provision of law that's seems bent on efficiency, to overread that into something that is very efficient is where
I understand.
I'm in trouble.
And the department's concerns about ultimately finality, making sure that years are closed, efficiencies in that regard, let's not pretend that that is only a concern for the Florida Department of Revenue. The Internal Revenue Service processes how many millions of returns every year? Certainly, finality and efficiency, and even under federal law, the statute of non-claim and a doctrine of laches, all that still applies. Yet for federal law, it's recognized, dating back to 1938 when the mitigation rules were put in place, that this is a very limited exception, and in these circumstances, Congress determined that fairness trumped that efficiency. And we believe that that concept of law ultimately is part of Florida law because the legislature intended to adopt and take into consideration all federal provisions that are not otherwise excluded. And in this case, the Department of Revenue, through the legislature, decided not to exclude the mitigation rules. Regarding the position that the Department of Revenue has raised that under Victor Chemical, which is, I think, their sole case that they rely on here, their lead argument is that Section 215.26, outlining the statute of limitations for claiming refunds under Florida law, is a statute of non-claim, permits no equitable exceptions. Again, this is a meritless argument for the reasons previously mentioned. The federal statute of limitations, 26 U.S.C. 6511, has also been determined by the U.S. Supreme Court to be a statute of non-claim. Yet, it's commonly understood by the Internal Revenue Service, who doesn't fight it, and the courts who enforce it under federal law, that the mitigation rules apply. Therefore, Victor Chemical, although an interesting case, is really not relevant to this case because the mitigation rules are an exception to the statute of non-claim. Your Honor, I've exceeded my rebuttal time. I'd like to reserve the balance.
Thank you. Mr. Cox.
Thank you, Your Honor. May it please the Court, I'm Clifton Cox, Special Counsel for the Attorney General, and I represent the appellee in this case, the Department of Revenue. This case hinges on the extent to which the Florida corporate income tax piggybacks the federal income tax. Florida begins with federal taxable income on line 30 of the federal income tax return. Florida then makes various adjustments in Section 220.13 to compute adjusted federal income and further adjustments to compute taxable net income. Florida also follows federal terms and concepts, but that's the extent to which Florida law piggybacks the federal corporate income tax.
Can I ask a quick question? This is just for information. The adjusted federal income on a federal tax filing will be a different number. In this case, maybe for Verizon would be a bigger number than a Florida adjusted federal income. Am I right? That
Not
there's a
necessarily,
Florida
Your Honor.
income and then there's a national income.
Not necessarily.
I get that, yeah.
Florida begins with line 30, which is federal taxable income on the federal tax return. But Florida then adds the various items listed in Section 220.13, subsection 1A, and subtracts the items listed in Section 220.13, subsection 1B.
Is that stuff like income from all the other states or whatnot that's not Florida?
That comes later, Your Honor.
Oh, okay.
That's after you have the adjusted federal income, then the department makes various additional adjustments dealing with non-business income allocated to Florida or other states, the apportionment of income, the unitary business income worldwide to compute the taxable net income in Florida. So the extent of Florida's adoption or piggybacking of the federal tax is limited to the starting point of line 30 and the fact that for efficiency's sake, Florida adopts the terms and concepts of federal law. Now, Verizon misreads the Seaboard Coastline case. The key language in that case.
So very quickly, I'm sorry, but going back to my question. So
Yes, sir.
before you strip out all the state-oriented stuff, you're dealing with a federal number, and so the federal and the state form is going to look the same by the time we get to the issues we're dealing with here, essentially. I mean.
No, Your Honor. There are, because of those changes in Section 220.13 that add some things and subtract some things, that's why you can have very different numbers for Florida NOLs or federal NOLs, why you can have, and of course NOL refers to net operating loss. And so there can be a profitable federal tax and a net operating loss for Florida or vice versa. Now, Florida's tax return is known as the F-1120 or Florida 1120, and the federal income tax return is the federal 1120. So the Florida income tax return deals only with adjustments after that federal taxable income on line 30. Did I answer your question, Your Honor?
I think so.
Okay,
Thank
thank
you.
you. Now, Your Honor, we believe that Verizon misreads the Seaboard Coastline case. The key language is at page 480, Southern 2nd, 1353. On that page, the court explains Seaboard filed amended federal income tax returns. Those amended federal income tax returns were audited and approved by the IRS. Seaboard then filed amended Florida tax returns, making the same adjustments that the IRS had approved on the federal tax returns. The present case does not involve any amended federal return. If the refund claim were based on an amended federal return, or if it were based on an IRS audit, pursuant to Section 220.23, Verizon would have had 60 days in which to file a further amended Florida return and an additional 2 years to file a refund claim in Florida. But because this case does not involve an amended federal return, the Seaboard Coastline case is totally irrelevant. It actually would support the department's position because the department notes if this refund claim arose from a federal amendment, Verizon would be entitled to it in Florida. It didn't, so they aren't. Now, the federal mitigation statutes mitigate or modify the federal statute of limitations in Section 26 U.S.C. Section 6511. Now, the case law that I have read indicates that the courts recognize that the federal statute is a statute of limitations, which is an affirmative defense. It does not deprive the courts of jurisdiction to hear the refund claim. One of the cases that the appellant cited, the Plausch-Lam case, noted that it is a federal statute of limitations. Now, Florida has its own statute of limitations on tax assessments, Section 95.091. And Florida has its own statute of non-claim for refund claims, Section 25.26. So there is no need for Florida to adopt the federal statute of limitations or any statutes that modify the federal statute of limitations. We would submit that Victor Chemical is dispositive. The Florida Supreme Court followed Victor Chemical in 1999 with the Department of Revenue versus Nemeth case, and if I remember correctly, the citation was 733 2nd 970. In that case, again, the Florida Supreme Court recognized that Section 215.26 is an absolute standard of efficiency. If a refund claim was filed, even in the Nemeth case, based upon a tax being unconstitutional, if that refund application were filed outside of the statute of non-claim period, it's barred. The court has no jurisdiction to consider it.
Are there instances where there are exceptions to the statute, the Florida statute of non-claim, that aren't dealt with in 215.26?
Your Honor, based on my research, no. Now, there are a couple limited situations where there is a tolling provision while an audit is underway. If the audit lasts for no more than 1 year, the certain deadlines are tolled. But for purposes of refund claims, other than those arising from amended federal tax returns that are addressed in Section 220.23, Section 215.26 provides efficiency and certainty. Now, Florida, unlike the United States, we have to have a balanced budget each year. We can't go back in time to grant massive refunds that would put previous years, would potentially create problems because of that.
So if Florida had mitigation rules similar to the federal government, you would expect them to be addressed or referred to within this section?
Yes, Your Honor.
Because this section you're reading far more robustly as a stronger bar than, of course.
Yes, Your Honor.
Right.
Section 215.26 on its face and is interpreted by the courts is an absolute statute of non-claim that, if it's not satisfied, deprives the court of subject matter jurisdiction to consider the refund. Now, the courts, Victor Chemical, made it clear. If we could consider fairness, well, there would be times when it would be fair to reopen that period. But the Victor Chemical Court said, while we might like that as a matter of public policy, the legislature said no. Any claims for refund filed outside the statute of limitations, with that limited exception of Section 220.23, when there was an amended federal income tax return and the taxpayer has an additional 2 years. Other than that, all claims are barred. Now, these refund claims go back very far in time. Florida, in Section 213 213.33 and 213.34, Florida places strict limitations on record keeping on the time of audits. And the taxpayers must maintain records for the time for which the department can issue an assessment. The deadline for assessments, section 95.091, generally 3 years. But if a taxpayer doesn't file a return at all, then the department could go back to the dawn of time. So if taxpayers file a tax return and there's no tax evasion, the department cannot audit more than 3 years before. And so taxpayers cannot be expected to maintain records.
Can you tell us how you read 220.02, the legislative intent?
Yes, Your Honor.
About utilizing the federal code?
And I think we need to read section 220.02 and 220.03 together, because section 220.02 states that Florida, for purpose of efficiency, adopts federal concepts and as developed, not enacted. Now, the legislature could very well have said, changed those two words, concepts of law, and developed in the federal income tax. It could have been changed to law or statutes and enacted, but they didn't. So those two phrases, developed and concepts, would refer to concepts like realization of income. Several of the cases that were cited in the briefs, SRG Corp., Heffler Construction, deal with realization of income. Those are concepts that are common both for federal income tax and Florida income tax. Concepts of law are not statutes enacted by the legislature. In the 75 or more years since Section 215.26 was enacted, there has not been a single case that has applied the federal rules mitigating the federal statute of limitations to mitigate the Florida statute of non-claim. Victor Chemical makes it clear that courts don't even have that power, even though in a particular case it might be equitable to do so. But it's a question of jurisdiction, subject matter jurisdiction for the courts. And the Florida Supreme Court reiterated the same principle in the Nimeth case many years later. So the courts uniformly have found the statute, Section 215.26, to be a statute of non-claim, but there is, by contrast, a statute of limitations on tax assessments, Section 95.091. The Florida legislature has a very fine-tuned set of deadlines for each step in the process of filing tax returns, of audits, of assessments, and refund claims.
Do you ever think that this 220.02 legislative intent provision, subsection 3, would be determinative of something, a case that we would have? I mean, it's an intent statute. I think that your brief went into that it's meaningful that this is about legislative intent, and it is the intent of, as opposed to an affirmative.
Well, Your Honor, I believe that we would agree with your observations earlier this morning that it's far more efficient to be able to use the terms, the definitions developed through ever since 1913 for the federal income tax. So you have realization of income. That was determinative in Heffler Construction, SRG Corp. You have profit and loss. You have similar terms that mean the same thing in Florida as they would for the federal system. I see my time is almost up. We would ask that the court affirm the portion of the decision below that found that Verizon's refund claims were untimely and therefore barred pursuant to Section 215.26. If there are no further questions, I'll be seated.
Thank you, Counsel.
Thank you, Your Honor.
Before you get started, counsel, I'll ask you to, can you respond to Appley's argument distinguishing Seaboard?
Seaboard Coastline case? Yeah, I'd love to. That was one of the points I was going to address. It was a good segue. The fact that Seaboard Coastline developed with amended returns is irrelevant, and I can explain pretty quickly why. Imagine the reason why Seaboard Coastline filed an amended federal return had to do with an issue that Florida treated differently. The fact that Seaboard Coastline filed a federal return with an amended return and therefore was required to file a Florida amended return would mean nothing in that case, because Florida wouldn't have adopted the change that caused the federal amended return to be. So again, the fact that it was amended return at issue in Seaboard Coastline is irrelevant. What's important in the case is that this court said federal concepts, in that case the claim of right doctrine under 26 U.S.C. 1341, were adopted as part of Florida law. The department didn't challenge it in that case. That particular provision, which is in the same subchapter of the Internal Revenue Code as the federal mitigation provisions, was part of Florida law. That is the important takeaway from Seaboard Coastline, not the fact that Seaboard Coastline had to file an amended return. Your Honor, there's a couple of things I want to make clear in the last minute that I have, and I think that they're critical to this case. Number one, the department does not dispute that the legislature intended Florida's taxing regime to borrow from the Internal Revenue Code. Number two, the department also does not dispute that Verizon qualifies under the federal mitigation rules for the requested refunds. They don't challenge the year, they don't challenge the amount. The department does not dispute that federal statute of limitations, like the Florida statute of limitations, is a statute of non-claim. Finally, the department does not dispute that the mitigation rules are an exception to the federal statute of non-claim. Your Honor, the mitigation rules apply in this case because the legislature has not expressly stated to the contrary, and the rules are not manifestly incompatible with the intent of the Florida legislature. For the foregoing reasons, Verizon respectfully requests that this court reverse and issue an order directing the trial court to grant summary judgment to Verizon. Thank you.
Thank you, counsel. All right, if counsel wants to take whatever time to gather themselves, but then we can move right into the next argument when you're ready. Feel free to have rooms off the back if you need some privacy. Mr. Cox?
Thank you, Your Honor. May it please the court, I'm Clifton Cox, and I still represent the Department of Revenue. I'd like to reserve 4 minutes of my time for rebuttal.
Noted.
Thank you. Verizon reads the last sentence of Rule 12C-1.013, subsection 15J, as if it ends after the statement, a deduction for the NOL carryover will be allowed to the extent of the amount allowed for federal purposes. Verizon ignores the rest of the sentence, which limits that deduction to the amount available for such taxable year. Now, the rule doesn't explain how to compute that limitation, because that's implied in the statute, Section 220.13, 1B, 1D, which directs that the Florida net operating losses, or NOLs, be treated in the same manner, to the same extent, and what's critical for this case, for the same time periods as the federal NOLs. Now, Verizon would like to substitute the phrase "in the same amount," but that's not in the statute. The department implements this implicit statutory mandate by allowing Verizon and other taxpayers to deduct the same proportion of the Florida NOLs as federal NOLs, so that they would be deducted in the same manner, to the same extent, and over the same time periods. But the statute doesn't use the word proportion. The reason the department understands that this is what the legislature intended is that it's the only way to ensure that those Florida NOLs are treated as the legislature directed.
That the what are treated? Say it again.
That the Florida NOLs
Yes, yeah, Florida NOLs, okay.
be treated in the way the legislature directed. in the same manner, to the same extent, and again, what's critical in this case, for the same time periods as the federal NOLs. Verizon's theory fails because it would allow Verizon to deduct the Florida NOLs acquired from MCI over slightly more than 1 year, while it would take more than 65 years to deduct all of the federal NOLs derived from MCI.
That is a surprising disparity, but looking at the text again, this is 22013, I guess it's 1B, the subtractions. There shall be subtracted from taxable income the net operating loss deduction allowable for income tax purposes. That net operating loss deduction allowable for income tax purposes is a figure,
Yes, Your Honor?
correct? For MCI, I think the figure is 241 million or
No, the
thereabouts.
241 million, yes, that's the Florida NOL. The federal NOL was $15,750 million and change.
Okay, but the federal limit on, per year limits that to
That's the $241 million,
Yeah.
yes, Your
Yeah.
Honor.
So, which is the number, are you saying, so that's helpful. The net operating loss deduction allowable for income tax purposes, you would say that number that they're talking about is 15 billion?
Okay, the total federal NOLs
Yeah.
derived from MCI were $15,750 million approximately.
Yep.
The federal limitation was $241 million. That's pursuant to Section 382 of the Internal Revenue Code. The Florida NOLs were $257 million approximately. Now, I think it's important, it would help the court to understand how the department performs the mathematics.
I guess what I'm interested in is this statute talks about a federal number and
Yes, Your Honor.
says that, that's the number that should be subtracted. And
But-
so I'm just interested in identifying what that number is for purposes of then going down and reading the however statement.
Yes, Your
later in
Honor.
the statute.
The department reads that entire provision in pari materia, and if you go down a little farther in the statute to the flush language, that's where the legislature clarified that they must be treated in the same manner, to the same extent, and for the same time periods. If the full amount of the deductible amount of the federal NOLs were applied to the Florida NOLs, as Verizon proposes, that's when the Florida NOLs are deducted over just a year, but federal, 65 years. So that couldn't be what the legislature intended.
Well, it seems to me like that's an applied thing that applied to this case, but it doesn't necessarily apply to that way in every case. And so that just happens to be, and it's a huge disparity. I get it. It's like, wow, how can that even be possible? But I guess if we get 20 of these cases, each of them are going to come to us looking a little bit different. And this statute is the statute. It applies across the board. And so if up top we're talking about a $15 billion number, and then when we get down here, for instance, to the treated the same manner, extent, time periods, if that means we're going from 15 billion to the 241 that the feds are limiting each year, then it seems like we're talking about a concrete number there that's already been sliced and diced through the manner, extent, and time period language, and that number just happens to be 241 in this case.
Yes, Your Honor. Now, if that methodology were applied consistently in other cases where Florida NOLs are greater than federal NOLs, then you would have just the opposite disparity. Now, the department is obligated to treat taxpayers consistently. The department's methodology in this case is intended to ensure a consistency so that there is no benefit or detriment from having either more or less Florida NOLs and federal NOLs. They're all treated consistently. Now, it's important to note, though, also, if the NOLs are incurred either by the taxpayer itself or by a member of the affiliated group, there's no limitation. This limitation derives from the federal rules in Section 382, limiting the trafficking and losses that that Congress recognized believed was a problem. Now, the way the department computes it takes, first of all, the federal limitation divided by the federal NOLs and multiplies that resulting percentage by the Florida NOLs. So if the company could deduct 20% of its federal NOLs in a given year, it also can deduct 20% of its Florida NOLs in the same period of time, and it could deduct all of the federal and Florida NOLs over the same 5-year period of time, which would be consistent with what the legislature directed in Section 220.13 1B 1D, that they shall be treated in the same manner, to the same extent, and what we believe is critical in this case, for the same time periods. Your Honor, the problem is clear. How do you reconcile those two provisions in the same statute? The department believes that the only way to ensure that they are treated in pari materia is to use this analysis of proportions so that they're all deducted over the same period in the same manner.
Yeah, and I get the fairness case. Just like in the previous argument, I get the fairness case, but I have trouble with the statute. Here, it's sort of the reverse. I get your fairness case, and why, but does the statute tell me that the answer is something different, is the trouble I'm having?
Yes, Your Honor. The statute, again, has two provisions that the department has tried to reconcile. And the only way, mathematically, that they can be reconciled so that the federal and Florida NOLs are deducted over the same period of time is by use of proportions. But admittedly, the statute doesn't use the word proportion. So that's why the department implements the statute, its understanding of the statute, trying to read all parts of it in pari materia.
And indeed, your own rule talks in terms of an amount, to the extent of the amount. But I
I'm
appreciate
sorry,
your,
yes.
but yeah, your rule talks in terms of the amount. But I appreciate what you said at the beginning, that the end of it talks about Florida NOL carryover available in such taxable year. So there are things to think about. Go ahead. Sorry.
Your Honor, if I may, I would like to, unless there are further questions, I'd like to reserve the rest of my time for rebuttal. Thank you.
Thank you.
May it please the Court, Michael Bowen, again, for this time for the appellee, Verizon Communications, Inc., and affiliates. The Department's position must be rejected for three independent reasons. First, the Department has promulgated an administrative rule entirely consistent with Verizon's position in this case. That rule is Rule 12C-1.013, subparagraph 15. Paragraph A of that subsection reads, Florida law follows the Internal Revenue Code with respect to the computation and handling of net operating losses. Subparagraph J reads, in computing the Florida corporate income tax, a deduction for the NOL carryover will be allowed to the extent of the amount allowed for federal purposes, provided that the deduction does not exceed the total amount of Florida NOL carryover available in such taxable year. That's the plain language of the Department's own crafted rule. The Department should be bound by the plain language of their own rule. There's no ambiguity in the phrase, to the same amount.
How about that last part? That's where he started, Mr. Cox started. The total amount of Florida NOL carryover available in such tax year. What are they talking about when they talk about the Florida NOL carryover?
Great question, and I'm glad I don't have to reserve time for rebuttal because it's going to take a bit. So we talked earlier about numbers. You asked questions about the Verizon's federal return, what those numbers would look like versus the Florida return. So let's just focus on the federal return. So for federal purposes, MCI generates losses year over year before they're acquired by Verizon. Let's say they generate $100 million in losses. Verizon seeks to acquire MCI. They acquire MCI, MCI files on the same return as Verizon. So the question for federal purposes is, can they use all $100 million of those losses to offset the income of the group or not? Federal law says no. Of that $100 million, which is the federal carryover NOL, you can only use this amount, and that's determined by Section 382. Section 382 of the Internal Revenue Code says it's a simple formula to figure out how much of that federal NOL carryover you can use. It's how much did you pay for MCI multiplied by the long-term federal interest rate. That number becomes your 382 limitation year over year. You can only use that much of MCI's $100 million on your federal return. Now that we're all tax experts on federal law, let's talk about state. So for state purposes, Florida does not follow exactly how the NOLs work for federal purposes. What I mean by that is for federal purposes, the MCI NOLs, you can carry it back and you can carry it forward. Florida law says, nope, we're not carrying it back. We can only carry forward. Therefore, for Florida purposes, that Florida total amount, that Florida total NOL available is going to be different year over year. Because for federal purposes, there's going to be carryback efforts. So the federal total NOL is going to reduce potentially vis-a-vis the Florida total NOL. So this last sentence here is just saying, look, if your Florida NOL is less, you can only to the amount of that cap. Does that make sense, Judge Osterhaus?
Yeah, that's helpful. Thank you.
My second point, Your Honors, is that the Department's administrative rule is indisputably consistent with the expressed intent of the legislature. Section 220.131B, which I believe Judge Osterhaus read, states that there shall be subtracted from such taxable income the net operating loss deduction allowable for federal income tax purposes under Section 172 of the Internal Revenue Code for the taxable year. More importantly, though, Judge Osterhaus, is that the same statute expands on this point by explaining that a deduction for net operating losses under Florida law is, quote, treated in the same manner, to the same extent, comma, and for the same time periods as are prescribed for such carryovers under the Internal Revenue Code. There's no ambiguity there either. The only difference between the statute and the Department's rule is in the statute it says to the same extent, and the Department's rule it says the extent of the amount, which is arguably the same thing. What the legislature is trying to get at here is whatever it is for federal, it's going to be for state. Period, amount, manner, time periods, all the same. Again, Judge Osterhaus, with the caveat that you mentioned earlier, which is in the last sentence, you can only deduct up to the amount of the Florida, whatever carryover amount that is. Whatever your bank of NOLs is, you can only deduct up to that amount.
So Florida has 2 less years because they're only going forward.
Correct.
Instead of backwards. Yeah. And so the number that, for this particular case, that B is talking about the net operating loss deduction allowable for federal tax purposes, for instance, in MCI's case, it's either the 15 billion big number or it's the 241 million annual allowance for the next 20 years and back 2 years.
My law professor in in law school used to tell me that the reason why I'm doing tax is I'm afraid of numbers. I don't pay attention to numbers all that much. What I will say is at the end of the day, your point earlier is a correct one. In this case, those happen to be the numbers. But in the next case that could be heard, it could be completely different numbers. It just happens to be the numbers in this case. The numbers shake out as the numbers shake out. And in this case, the numbers have been stipulated to. So there's no question as to what the numbers are. It's merely an application of what the law is. And in this case, it happens to be that MCI's numbers and Terramark's NOLs are what they are, and the federal and the Florida numbers are what they are. But it could very well be the case that the numbers could be substantially less. It could be the case that the Florida carryover amount could be almost nothing, in which case Verizon wouldn't have been able to take any deduction because it would have been capped. But that didn't happen here. Verizon had sufficient NOL carryover for Florida purposes to take these deductions. It might not be in the next case.
So what happens in a situation, which maybe Mr. Cox said could happen, where there's no federal NOLs, but there are state NOLs? I would think that the state would get swept into the federal, but maybe not. If your federal NOLs are zero, but your state NOLs are something, does the rule you're asking us to adopt mean, sorry, we're not going to recognize your state NOLs because your federal number is zero?
Not going to recognize, well, you wouldn't be able to claim a state NOL because there's no federal deduction. Remember, state follows federal. So if there's no NOL deduction under Section 172 for federal purposes, because you're out of NOLs for federal purposes, it doesn't matter that you have a Florida NOL carryover amount for that particular tax year because you haven't claimed a deduction for federal purposes. There is no NOL deduction for Florida purposes because there's no bank for federal NOLs to use. There's no deduction under Section 172. You would have to wait till the next year. Maybe that entity generates losses then, so then you have a federal NOL, and you can use against the Florida NOL carryover.
So the federal number is always the determinative number. There isn't such a thing as a recognizable Florida NOL separate from the federal NOL.
And that's what the legislature intended. We're going to follow federal. Whatever the federal is what we're going to be doing here for Florida tax purposes, with the caveat that because Florida NOL, the bank of Florida NOLs may be different because of carryback, that number could be different. So the bank of Florida NOLs that you're offsetting against could be less. And that's the only caveat that's applicable, but it's not even applicable in this case because Verizon had sufficient NOLs carryovers to use in this case. It was already been stipulated.
So if the federal NOLs were extinguished by using the 2 years back, and so they had a zero balance going forward, the same number would be used in Florida, but it would just go forward?
Yeah, you wouldn't be able to use them, right.
Or you wouldn't-
You wouldn't be able to use them because you've taken them in past years. You chose to carry back for federal purposes, but you can't carry back for Florida purposes.
I see. So it's meaningful that each tax year is sort of standing on its own.
Every year there's a decision to make. How do you want to use your NOLs? Because you might not be a state benefit. Florida's not alone in not permitting carrybacks. There's a lot of states that don't permit them. So, Your Honors, the Department's proposed 382 limitation formula, although superficially appealing, is based on a faulty premise. Specifically, the Department presumes that there's a mathematical connection between the calculation of the 382 limitation and the net operating loss carryover amount, which we've talked about a minute ago when you became tax experts, when I explained to you how the whole NOL thing works. The Florida, even when we're talking about IRS or Florida, the NOL carryover amount, the bank as I call it, is determined based on a year-over-year basis, net, how many of your losses. And that number keeps going up and down based on your profitability on a given year. The 382 limitation will stay the same. It's based on what was the purchase price of the company that you acquired and what's the long-term federal rate. That is the amount of the subset of the bank that you can use on an annual basis for a deduction. Those two concepts are unrelated for federal purposes, and as a result, they're unrelated for Florida purposes. So the Department's formula, which wants to use the same proportion, assumes that there's some sort of connection between those two, but there's not. There's not for federal purposes. The formula for federal purposes is what it is, and the bank of NOLs is what it is as well. There's no connection between the two. They're not related. And that's where the Department has a faulty premise here by assuming a formula that assumes that particular connection. Now, Your Honors, you won't find that formula in a Department rule. You won't find it in a statute. You won't find it in a ruling. You won't find it in a case. First I heard of it was in this particular case. It doesn't exist. That formula is nowhere to be found. It's not, the Department hasn't promulgated a rule relating to it, hasn't proposed a rule relating to it that I'm aware. It's new. It's
So this would be rulemaking through judicial
judicial
fiat or
fiat.
something
Yeah,
like that.
that's correct. Your Honor, we're relying strictly on the administrative rule. We believe the Department should be bound by their own administrative rule. It says to the same amount, and that's what we've done here. The parties have already stipulated as to the amounts in this case. The Department should not be permitted to argue against its own administrative rule, and as Judge Osterhaus indicated, it's not for this court to legislate on its behalf. So for the foregoing reasons, Verizon respectfully requests this court issue an order affirming the decision of the lower court, granting Verizon summary judgment in this case.
Do you think it's odd, or should we be struck by the fact that this would take 65 years in the federal context to use all of these losses, whereas it takes a year plus change with respect to how Florida would treat it?
I think, as you mentioned earlier, Judge Osterhaus, that just happens to be what the facts are, though. A different taxpayer could be completely different
But
result.
that's pretty striking, though, right? 65 years versus 1 or 2.
Just happen to have a very large bank of Florida NOLs, ultimately, at the end of the day. That's just unfortunately the way it worked out. It wouldn't work out that way for every one of Verizon's subsidiaries. It just happens in MCI and Terramark, that's the way it worked out.
Well, Terramark's numbers look different, right? I mean,
Smaller.
They're, yeah.
And again, I'm not a numbers guy, but I know they're smaller.
Yeah. I mean, their total was 308 and their yearly Fed limit was 128 million, so they're going to get mopped up in a few years, it looks like.
Correct, in a few years.
I also have just one big picture question, mostly out of curiosity. Are there any other refund claims after 2013? Anything pending with similar issues or any rule challenges or anything pending that
No.
are going to be determined by this case?
No, not that I'm aware.
Okay.
Judge Kelsey. That's all. I'll rest.
It's important to note that the years in issue are 2011, 12, and 13. The law has changed multiple times since then. In 2017, the federal law and state law changed. That's irrelevant for this case, but as you research the issues, you may see that. No longer is there a 2-year carry back for the federal. No longer is there a 20-year limitation. The NOLs can be carried forward forever until they're used. So the issues here don't have a significant ongoing consideration. Now, Judge Osterhaus, you asked a question I'd like to address. Under the department's methodology, if there are no federal NOLs, no federal NOL limitation, but there are Florida NOLs, how would the department address that situation using the department's methodology? Using the department's methodology, you'd divide again the federal NOL limitation of 0 by the federal NOLs of 0. The resulting number is infinity multiplied by the Florida NOLs, so all of the Florida NOLs could be fully used without any limitation whatsoever.
Do you think we should be concerned about sort of recognizing a principle like that via judicial decision versus testing it through the rulemaking process?
Your Honor, the department believed that the rule was clear until this case. This is the first time that the issue has been addressed in the courts. So would it be nice if there were a new rule? Absolutely. Or if a new statute? Absolutely. But dealing with the wording of Section 220.13, 1B, 1D, how do we reconcile those two provisions? The one earlier in the statute, the one later in the statute that provides the overall limitation, and the directive that they be treated in the same manner, to the same extent, and again, what the department believes most significant for this case over the same time periods.
And I get that it might be a really nice way to do it and a fair way to do it and a good way to do it. It might be the best. There might be 5, 10, 20 different ways to do it, but that's a good one. But for us to say that it's so clear that that is the law in Florida, that this is the way you do it, seems like that's a little bit of a leap. What do you think?
Your Honor, there's got to be an answer. Both taxpayers and the department want consistency. We don't want a situation where one taxpayer argues one way. In this particular case, Verizon has proposed 3 different approaches using Verizon's own apportionment factor, using the subsidiary's apportionment factor, and its present latest theory. Other taxpayers also may come up with other theories. The present case is the first time that this issue has come before the courts. The department has tried to implement the Florida statute in the only way it knew how in order to comply with that language in Section 220.13, 1B, 1D. The other methodologies that Verizon proposed, the brief explains why they are improper. So,
Do you have any problem with how your brother read the end of that part of the rule, the total amount of Florida NOL carryover loss available in such taxable year, that essentially points us to this fact that the federal government, the years available for applying these losses are different. And so you have a Florida NOL, federal NOL, and that's the reason.
Your Honor, it doesn't say the NOLs that are available. If that's what it said, that would be consistent with Verizon's theory. But it says what is available for such taxable year, which means that there is an annual limitation under Florida law, in addition to the annual limitation under federal law. The rule doesn't explain how to compute that annual limitation. That's why the department has attempted to implement the statute in the only way it mathematically can work. My time is up. If there are no further questions, I'll ask that the court approve the department's methodology for computing the Florida NOL carryover. Thank you very much.
Thank you very much. Thanks, both counsel. That was very helpful. And I think that's it for today. We'll be adjourned.
All rise.